Let's begin today's presentation, which I'm very excited about today. We are going to talk about order approving settlements in New Jersey, but we're also going to talk about the decision that we just got. So let's dive in. All right, today we're going to talk about orders approving settlement, the difference between Section 20s and Section 22s in New York. Some of you might be here today because last week I announced that we got a Supreme Court win in New Jersey. And really, it wasn't a win in so much as the Supreme Court said, hey, we're not going to disturb what the appellate division did in affirming your trial win. Okay, so essentially what happened is the Supreme Court said, you know what, we're not going to disturb, mess with, review, or reconsider the result that you got in the appellate division. And that's an important result. The case that got appealed by our adversary was a case involving an alleged occupational exposure. Now, I'm not going to go through the bizarre facts of this case because they're frankly unimportant and the case itself is not interesting, but it did involve an alleged occupational exposure, inhalation injury causing issues to someone's lungs and in fact a lot of internal organs. So that's the claim. The judge of compensation, after reviewing the proofs and listening to the experts, disallowed the case, dismissed it, said, sorry, this isn't a workers' compensation case. You have not proven causation and you have not demonstrated that there is any correlative link between your alleged exposure and to these alleged conditions you have, right? So that's the judge's decision. It gets appealed by the petitioner on a lot of grounds, among them that the judge of compensation credited the testimony of the expert for the defense and didn't credit the testimony of the expert for the plaintiff. Okay, that's a typical thing that gets appealed, and that admissibility of expert opinions ended up being sort of the crux or the biggest issue in the case. Now, the appellate division reviewed this and said, you know what, actually, the workers' compensation law judge did the right thing in finding that your experts are not as credible and can't give weight to their opinions. But they went a step further, and this is the part that's like a little new or interesting or nuanced or useful for us. And they actually just went and said, you know what, the same standard for admissibility of an expert opinion in a civil action applies here in a New Jersey workers' compensation case. So that's pretty interesting, and that actually breaks with what the court's decisions have said in the past, where they've said, well, the rules of evidence don't really apply in a workers' comp case. This decision says, actually, you have to comply with Rule 703 of the Rules of Civil Procedure, which says that an expert opinion, if it's going to be considered or given credence by a judge, has to be, quote, grounded in facts or data derived from their personal observation, evidence admitted at trial, or data relied upon by the expert, which is not necessarily admissible itself in evidence, but which is the type of data normally relied upon by the experts. So to unpack that, like what does that mean and how does that impact our cases? Well, essentially it means that Rule 703 should apply to the admissibility of expert opinion in New Jersey workers' comp cases. And there is, by the way, a large body of case law that has examined exactly what that means, which is new, right? Because that's now going to be something that we're going to be able to utilize in our workers' compensation case. Now, part of Rule 703 says that net opinions are not permissible, and that's great. We've made that argument many, many times and prevailed on it, and most judges are going to not let in purely net opinion into the workers' compensation context. But Rule 703 also has a prohibition against net opinions, which I think is going to be useful for us. Now, I think this applies. In any case you have going forward, and really going backwards as well, where the petitioner's expert is basing their opinion on records or reports where we don't know where they came from or what they're based on, right? So an example that came from the case that got decided by the appellate division here, the expert is issuing opinions saying essentially that this claimant's injuries were from exposure to a specific chemical, but there was problems like, was the chemical ever even in the car? Did they have the right chemical? Did they even have the right name of the thing? They did do some testing, some scientific testing, but did they even test the chemical that was actually present at the alleged work site? So there were all sorts of problems with chain of custody. And I think about that. very simply in terms of, hey, where do these medical records come from? Who reviewed them? Particularly in the age of things like generative AI, which can come up with fake medical records like pretty easily. That's going to be an important thing for us to challenge. Hey, where did this record come from? I know in the context of COVID cases where COVID tests were being sent to out-of-state labs to be verified that the person was COVID positive, we challenged whether or not those labs that were out of state had a valid chain of custody for these alleged, findings, right? I mean, our argument in those cases were essentially like anybody's nasal swabs could have been mailed off to those Virginia testing facilities and given a positive test. That's who had the chain of custody. So that's one, sort of overbroad, but maybe applicable use of this case. But where this case is useful is information that's only obtained from the petitioner. In other words, if the only statements about the exposure or the trauma or the repetitive use comes from the petitioner, well, that's going to be suspect. I mean, because they're going to be basing their entire opinion on what one person's hearsay testimony, which is not going to meet the requirement of the rule. And the last step is the last thing that's going to be useful for us in challenging admissibility is where the expert just makes these big leaps and says, well, based on nothing, here's what I find, okay? And I have cases where this is going to apply right now. I've got a case pending where the claimant alleges that the dependents claim that the decedent died because of exposure to something specific in the workplace. But there's no proof of that actual exposure. The only thing they have is the family members say, hey, we believe it was there. That's just not enough. That's a speculative or causative leap. I think this will apply actually even more usefully in cases involving degree of permanent residual disability, because the experts that are relied upon by both parties are now going to have to say, here's what I base my finding of disability on. They can't just say, oh, I've done this for 50 years, and when someone says they sprained their back, I always give them a 27.5 of partial total. Nope, you have to explain the scientific or reasoning basis for that determination. And it cannot just be experience, my personal experience. That's not going to be enough. They're going to have to say, well, I'm basing it on, my findings, my physical findings, the complaints I got from the claimant, and also this comparison to, and then they'll have to tell us, what is the scientific or accepted basis for the opinion that they're coming out with. So I think this is going to be incredibly useful in challenging these all over the board permanency evaluations. And I also think it's useful in that it challenges the great leeway that the courts, the workers' comp judges have afforded to these experts that come in, particularly orthopedic experts, pulmonary experts, and psychiatric experts that we see in all of our cases. There was a case that was decided in 2003 called Lindquist. And in that case, the New Jersey Supreme Court found that, quote, the rules of evidence do not apply to workers' compensation proceeding, close quote, which a lot of judges have taken to mean, well, I can kind of accept proofs which are a little bit marginal, questionable. The basis for them hasn't really been laid. There maybe not, there maybe is no parole evidence for the things that claimants are alleging, but I don't have to apply the rules of evidence. And that's always been used against us in the defense when we say, wait, show me, prove it. We're going to bring our healthy skepticism in this case and say, wait, how do these two things connect? Or how is this causation actually related to the workplace exposures? The other side could rely for the last 23 years on Lindquist, which just said, well, rules of evidence don't apply. But our new decision, what we just got, says, actually, you should apply the rules of evidence, and particularly Rule 703 in regards to expert testimony. So that's absolutely a huge change. And I think there's going to be an impact beyond occupational exposure cases. Because all experts are going to have to identify what's the factual basis and what's the methodology that they're using to come up with their opinions. Now, I think this is going to have an impact on permanency because in New Jersey, there is no published methodology for determining permanent residual disability in a New Jersey workers' compensation case. I'm going to repeat that because it's so insane. There is no published methodology, no scientific standard, no medical standard, no generally accepted way that the individual physicians are to estimate permanent residual disability impairment. It's not published anywhere. And in fact, everybody's resistant to this. When you ask opposing counsel, like, how come when it's an occupational exposure case, Your permanency experts will look at MRIs and they'll say, look, all of this degenerative worsening that happened over time, this is to be expected. Someone who's worked in this profession for 50 years, walking, talking, moving around is going to be expected to have, issues with their joints and all sorts of disability and problems with their low back. And they will ascribe that to the workplace. And they'll say it's because of, 50 years of long employment exposure. But that same MRI, same claimant who's had a specific trauma, they will then ascribe all of that disability on the exact same MRI to that specific accident. And the reason is because that suits the facts of the case, right? That methodology and the methodology that they bring to these cases in which they essentially assume causation and just assume impairment, that's going to be under attack. So this is a real great opportunity for us to sort of demand a higher standard of proof for some of these outrageous claims that we have to defend. So I think this is going to be really useful for us and hopefully helpful to you. So today in the handouts, I put a copy of the appellate decision that references Rule 703, which again, I think I've done a survey of all the workers' compensation law decided in the last 20 years since Lindquist. This is the first time that I've found an appellate decision that says, nope, your expert opinion in a workers' compensation case has to meet the standards of admissibility under Rule 703. That's just a huge thing. And it actually challenges or goes against or helps us really refine and maybe keep out some nonsense that was allowed in post-Lindquist. So I hope that's useful for you. I'm going to be happy to answer any questions that anybody has about both that Supreme Court decision that affirms or essentially says, I'm not going to disturb the appellate decision. And you can bet that in my cases going forward, I'm going to be strenuously arguing against net opinions, against speculation, and against unfounded and unknown mystery methodology that the petitioner's doctors utilize to determine permanency. So we're going to be going after all those things, and I think that's going to be a ripe area of development going forward. All right. So that's a little bit about the big news from last week. Let's move into today's topic, which I really want to talk today about how do we protect you against reopeners and how do we do the best job we can possibly do for you in moving cases quickly to settlement and getting those settlement documents correct and accurate and being very specific about what we're doing in those settlement documents so that we don't expose you to the potential for a reopener. So I've included today in the handout some excerpts from my handbook, particularly chapter 10, which really does talk about this. Here at LOIS, our system is that everything is generated via templates. We have really a lot of one-click workflows for generating things here. Orders approving settlement and Section 22 orders, we prefer to create those orders, and we generally, that's something a paraprofessional can do here, and we prefer to send them to opposing counsel. And that's in opposition to what I think is a lot of very common practice where people say, hey, we've reached a settlement in our workers' comp case. Why don't you, petitioner's attorney, generate the order, send it over to me, and then I'll sign it after your guy signs it. And it kind of slows down the process and puts it in the hands of someone else. So we prefer to generate the order here. Our goal is to present a very clear, specific order that covers all four corners, every issue you can possibly have. And there are some issues that you can address, and you should, by the way, address them long before you get to the moment of resolving or settling your case. And the big ones are issues surrounding wages and rate. That wage and rate should be calculated early. Wage in New Jersey is pretty simple. We don't have any forms. Our statute says there's a 26-week essentially look-back period for wages. It's pretty straightforward. Oftentimes we'll have missing weeks or incomplete wage statements. In New Jersey, we're going to be guided by fairness to try to come up with a realistic and representative average weekly wage. Rate, okay, the rate at which compensation is paid in New Jersey is going to be determined by that average weekly wage. So we want to get it right. We want to do the right thing. Just please note that reconstruction is allowed and acceptable for permanency awards. And so in those contexts, just be on the lookout for part-time employees, particularly your younger employees or your student employees who are working less than 20 hours a week or less than 25 hours a week. Those are the ones where reconstruction might apply. I'm going to skip through a lot of stuff that we don't really need to go through because it's pretty straightforward. New Jersey has scheduled loss of use and enumerated body parts. We call this, quote, the front of the chart, okay? hands, finger, feet, toes, eyes, ears. Just like many other jurisdictions, enumerated scheduled body parts, very easy, very straightforward. New Jersey also has a concept of permanent partial disability. This is a impairment state, not a wage loss state. In New Jersey, you can get an enormous award of compensation and never lose a day from work. New Jersey compensates people for medical impairment and impact on daily living, not impairment of their working ability. And oftentimes, and in some contexts, you will see there is no impairment of their working ability, but they got giant workers' compensation awards. Well, there's two reasons for that. One, you're in an impairment state. In an impairment state, you can get giant awards without showing any wage loss. So that's straightforward. The second thing is New Jersey's compensation schedule, which is encapsulated in Section 12 of the statute, includes in it bumps or humps, depending on how old you are. When I started, we always called it the hump in the chart. As you go up the increasing amounts of disability in terms of percentage, the number of weeks radically increases. Okay, so an example, the first major bump or hump is at 30% partial disability. At 30% partial disability, you are entitled to an award, and I use 2020 rates just to match what's in the handbook, which excerpts that I included in today's materials. 30% partial disability is 180 weeks, payable at $308.90 per week, or about $55,000. Okay, makes sense. 31% disability, so just a 1% increase in disability, is 180 weeks of compensation paid at a much higher rate and yielding an award which is dramatically higher. So we've only gone up 1% in disability, but we've gone up almost $30,000 in exposure. And you've got to be mindful of this when you're drafting orders and when you're considering the impact on reopeners, right? You don't want to settle cases with the knowledge that if the case comes back and there's a reopener, and let's say you settle a case at 30% permanent partial total, they come back and do a reopener and they get a 1% increase. Well, they didn't just get a few $1,000s. In this instance, they would get almost $30,000. Again, it's something to be very mindful and thoughtful about as you craft orders and as you settle or negotiate the settlement of cases, how close you're getting to those statutory bumps. Now, figuring out an award in New Jersey is tremendously easy. New Jersey has a calculator that they publish online. It's called the Oscar calculator. Don't ask me what Oscar stands for. And it's for calculating all forms of disability. It's an excellent tool. All the judges rely on it to double check everybody's homework. So we tell our clients, hey, use the Oscar calculator to come up with your exposure analysis because it's going to be what we're going to rely on in court. New Jersey also has an interesting rate cap, which, even though there are published rates of compensation for each level of disability, that is going to be capped by the petitioner or claimant's average weekly wage pre-injury. Their workers' compensation rate can never exceed their pre-injury wage. And so for low wage earners, people earning less than $500 a week, there's going to be essentially a cap on how much money they can earn in their workers' compensation award. It's standard, makes sense. New Jersey also allows for stacking of disability awards. Multiple separate injuries arising from the same date of loss will be stacked on top of each other. So this is someone who falls down a flight of stairs and they sustain an injury to their thumb, they have an ankle injury, and maybe they sprain their shoulder. Those injuries are not going to be compensated separately. They're going to be summed together. The number of weeks are going to be added, and this can result in a very high award, particularly where those awards start to go over those bumps or humps in the statutory scheme in Section 12. So just be mindful when you have many injuries in your workers' compensation case, you're generally going to be talking about a stacked award, a cumulative award, which is going to be often a lot higher than just adding up the individual awards for all the different body parts. Now, there is case law that stands for the proposition that you do not automatically stack disabilities in occupational exposure cases. So the claimant who files an occupational, a post-retirement or plant closing, and they file a hearing case, a pulmonary case, and a cumulative repetitive trauma case, those should not stack. And for that reason, some of our opposing counsel, I can think of one firm that does this, always files separate claim petitions for occupational exposure cases, and it's because they recognize that there is no stacking that's going to automatically apply in those cases. A common question I get is what happens if the petitioner dies while they're collecting their permanency award? Well, if they're less than totally disabled, they get whatever the balance due is to them. If they are totally disabled, meaning they were on a permanent and total disability award, all benefits end or terminate as of that moment. And again, we're making the presumption that they didn't die of something related to the workers' compensation case. Another interesting thing or thing that we should be thoughtful about in New Jersey is what happens with indemnity benefits, and particularly the transition from temporary disability benefits to permanent disability benefits. This is one of those areas where being savvy and understanding the complexity of the law can really result in a huge advantage to you, and I want to explain exactly how. Under our statute, benefits generally run consecutively. After each week of indemnity benefit, when there gets to a time for a permanency benefit, that should go back and begin immediately or consecutively after the indemnity period ends, that temporary total disability period ends. Our statute does not prohibit filling in, which means, let's say someone gets injured at work and they have a period of temporary disability. Then they're able to come back to work and they work for a few months. Then they have to go back out for a second surgery or some treatment and they lose time again. And they get entitled to temporary disability once again. And then they come back to work and then there's a period of months, let's say, before their permanency award is ordered. Normally, you can go and pay permanency awards right back until the date of last payment of temporary disability, but New Jersey also allows you to fill in the gaps. So those time periods during the pendency of their workers' compensation case, when they were going from temporary disability back to going to work, we can fill in all of that time period from the date of loss up until the date of the entry of the order, accrue the benefit, and pay it all at once to the claimant. Now, there's an argument that's made, and this is called, by the way, filling in the gaps, okay? And I love to fill in the gaps because what this does is it, accelerates the payment of the award, it puts more money in the petitioner's pocket, and it should shorten our reopener period, right? So for those reasons, I like to do this, and this is something that we want to be very thoughtful and clever about making sure we try to implement. Now, there is no case law that says that the reopener period is shortened by doing this, but I think it is, and I think if you really think about what the filling in the gaps and consecutive payment of compensation means, it means, yes, if we fill in the gaps and we shorten down the period that we're going to pay permanent residual disability, because remember, payments are made over a course of weeks, that should reduce our reopener period as well. Okay, now there is some case law which seems to suggest the opposite, but again, this is a place where I think we should dig in and be willing to make case law on this issue. So if anybody has a case where this is a topic or an issue that's come up, and the question is whether or not the reopener period has elapsed, please talk to me. I'd love to help you form your legal analysis in that case. All right, let's move into our last topic here, which is how do we prepare these orders to protect clients, and how do you protect yourself, particularly from reopeners? Now, remember, New Jersey has two settlement types. One is called Section 22, or order approving settlement, and one is called Section 20. Now, if you don't learn anything else in this brief webinar, please know that Section 20 are our preferred way of closing cases. And they're our preferred way of closing cases because they are not subject to a reopener. You pay the case out once in one lump sum payment. You may have, because if you're foreclosing future medical, you may have a Medicare as future payer obligation to consider, but these are generally quick, clean, simple, and they're closed, which is my favorite word in the English language. In contrast to that, an order approving settlement is not a closed settlement. I mean, the word settlement it's not even a settlement, really. All you're saying is, hey, at this period in time, this is the amount of permanent residual disability I have right now. It does not limit the petitioner from coming back anytime within 2 years of the last payment of compensation and claiming that their disability has increased. And guess what? They're monetarily incentivized to do that, so that's why they file so many reopeners in this jurisdiction. More than 1 in 5 cases in our jurisdiction is a reopener of a previously resolved or settled case. I hate reopeners. The one good thing about reopeners is the burden of proof shifts to the petitioner to demonstrate that their condition has worsened. However, But reopeners are just a waste of time, expense, and litigation resources in my experience. Generally speaking, there are no objective proofs that can show a worsening of their condition, and these cases then generally resolve by way of a Section 20 lump sum dismissal. And for this reason, I hate Section 22 settlements. I hate order approving settlements. My clients hate them. The only people that seem to really like them are the workers' compensation judges and the attorneys representing the claimants, because for the workers' comp judges, it helps justify their job that they have all these cases being refiled and reopened, even though they're going to get settled out probably for $5,000 Section 20. What are we really doing? And petitioners' attorneys like it because it's another chance to get a fee, right? But that's it. I mean, there's no benefit to the petitioner. Rarely did these actually result in an increased finding of overall disability. And the number of people who are actually protected by this reopener procedure is pretty small in my experience. Anyway, in this jurisdiction, about 2/3 of the cases resolved the first time by order approving settlement. And after that, about 2/3 of those resolved by way of Section 20 or lump sum dismissal. All right. Order approving settlements can never be forced by a judge of compensation. Now, judges are very active in this jurisdiction and they love to participate in settlement discussions. Even when we present to them a settled case, the judge will still say, well, I want to look at the documents and I'll decide if I'm going to approve it or not based on my opinion as to whether this is a fair and just settlement. Sure, they're required to do that under the statute, but in most jurisdictions, they are very happy to just rubber stamp settlements, not in this jurisdiction. But they can never force you to do a settlement in New Jersey. There is no such thing. If the judge says to you, hey, what you're offering in this case is not enough, you should increase your offer, and you don't think that's correct, you can go to trial, okay? You do not have to do a Section 22. Please note that every settlement in this jurisdiction must be approved by a judge of compensation, so you're going to get that input into your settlement whether you like it or not. Another thing about Section 22s is the award is paid over weeks. It is not paid at once. Any accumulated or cumulative weeks from the time permanency was reached, which is generally found to be the day after their total temporary disability ended, at that moment, you're going to have maybe some accrued weeks, but unfortunately you have to pay the awards out over weeks. That's in the statute. I can't change it. I wish I could. But what it means is even when you're resolving a matter, you may have an obligation to pay forward into weeks. And each time you make that payment of compensation, you are extending the statute of limitations for the petitioner to file a reopener by an additional 2 years. So just be mindful about this relatively annoying aspect of the workers' compensation law in New Jersey. Now, New Jersey also allows for apportionment of attorney's fees. And what this really means is in most settlements, you should plan for or budget to be exposed for compensating petitioner's attorney for their time and attention. What? This is a settlement. Shouldn't their own client pay that? Sure. Not in this jurisdiction. The judge will generally apportion fees. Generally speaking, the judge's fee is, they're generally going to apportion it 60% to the respondent and 40% to the petitioner. And I'm going to change this slide. There is a slight error on this slide. The maximum fee for petitioner's experts is now $1,000. The second slide is actually correct. So in an example award where $10,000 moves to the petitioner, you should know that the attorney's fee will be between 20 and 25%, depending, with 60% of that paid by the respondent. So you're going to have additional exposure. What happens in court? Well, the judge is going to review the paperwork. They're going to confirm the voluntary acceptance of the settlement. They have a set litany of questions they're going to ask the petitioner. The petitioner can then testify about their current complaints and limitations, and we have the opportunity to cross-examine the petitioner on those. Now, two things. First, in this jurisdiction, more and more settlements are being done, in fact, primarily are now being done on paper without any testimony from the petitioner. That's okay. It is very important, in fact, crucial, that whether the petitioner testifies in court in furtherance of their award, or they produce a document, and in the document they say, I want to accept this award, and I'm going to accept it voluntarily, and I understand I have a right to trial, and I am waiving that right, and they have to literally write out all their acceptances. We also want them to write out all of their current complaints and limitations. And the most powerful thing we can do is get them to testify or affirm, and that again be by way of their certification or affidavit, that all of the complaints that they gave to their expert are the same today as when they gave them to their expert. Because generally, when they go to see their expert, they're going to come up with their pie in the sky, a million complaints and all the issues and all the limitations they have, all the sporting events they can't conduct, and all of the limitations in their activities of daily living. We want to solidify that and crystallize that and freeze that in amber, because when the petitioner files that reopener claim down the road and they claim their condition is worsened, we want to be able to point back to their testimony, either at the time of settlement or their affidavit, and say, how could it be worse? Back then, you said you couldn't walk a block. You couldn't go up and down a flight of stairs. You couldn't drive. All of these crazy complaints they give to their experts, we're going to then use to inoculate ourselves, to immunize ourselves against that reopener that they're going to file. So it's crucial, critical. This is probably one of the most important things that your defense counsel can do for you at the time of settlement, is make sure we crystallize and freeze in amber all of the petitioner's complaints so that we do not have to defend that reopener, and we have an easier time, I should say, defending that reopener. Now, Section 20s, again, my favorite kind of settlements. These are lump sum dismissals. Again, the judge can never force you to do a Section 20. A judge can only issue a judgment or an order. They cannot force a settlement. They can only approve a settlement. So you should never feel like you're getting bullied into doing a settlement that you don't want to do in a workers' compensation case in New Jersey. Again, just like an order approving settlement, every single Section 20 settlement needs to be approved by a workers' compensation judge. There are no out-of-court settlements or dismissals allowed in New Jersey. Now, I love Section 20s. It's one and done. You pay them once, you never see them again. They can't bring the case again against you. And I would Section 20 everything if I could, but I can't, because there's a strong judicial bias against doing a Section 20 in every case. In fact, the judges tend to want to approve orders approving settlement and will not, in many cases, approve a Section 20 until there's been a reopener of that original case. There's a legal requirement for Section 20 to be appropriate, that there has to be an issue in dispute. However, the nature and extent of permanent residual disability is a valid dispute as a foundation for a Section 20. So it really should be available in every case. But you're going to be swimming upstream and pushing against judicial bias in this jurisdiction if you're fighting for a Section 20 in every case. The last thing we'll talk about is that New Jersey also allows for what's called a hybrid settlement, and that's where a portion of the case is resolved by way of order approving settlement under Section 22, and a portion of the case is dismissed under Section 20. This typically happens in your fall down motor vehicle cases, in which they bring an orthopedic case, which is an accepted component of the case, but then they bring a disputed case, like a PTSD or a psychiatric claim that we're going to dispute and we don't want to be on the hook for future medicals for. In those instances, we will sometimes recommend a hybrid settlement in which the compensable components of the case will be resolved by way of Section 22, again, subject to reopener, and then the less compensable or more defendable issues are resolved by way of Section 20. So you always have the opportunity when you're crafting your settlement to think about how you want to position the settlement to make sure that you are taking advantage of the benefits of both of those laws. All right, some takeaways before I break off into questions. Crafting the order correctly, getting it exchanged between the parties quickly, and then getting it into court as fast as you can. You know, most judges are going to allow us to do an add-on proceeding, so you don't have to wait for a court listing to reach a resolution in your case. But an accurate, easy to read, clear order is key. Next, you can settle a workers' compensation case via either method, whether it's a Section 22 order approving settlement, again, subject to reopener, or a Section 20. Know the differences, know when one is better than the other. Our preference is almost always for a Section 20. All right, let me come over and just see if there are any questions that I should be answering. Okay, Tim says, where can I find the handouts? Let me see. Thought I put them in here. Okay, I hope these are coming through for you, Tim. Okay, I hope that worked for you. And let's see, Q&A. All right, if there's no questions, it sounds like we're in good shape. Thanks for joining me today and my first run through of this new tech system. It's been a little bit of an adjustment, and I do appreciate everyone's attention and also the grace as we all are getting used to this new stuff. All right. A little technology hiccups today just to get through. I'm using the same system to do a webinar on Wednesday, so hopefully by then I get this all sorted out. All right. Thanks for joining me, everybody. Have a great rest of your week.